Sorry for the delay, everyone. Good morning and welcome to a special edition of Virtual Face-to-Face with President Bruce Jarrell. I'm Alex Lakowski, Executive Director of Media Relations. It's a five-alarm fire, Democratic Senator Patty Murray of Washington State told a crowd assembled on the steps of the Capitol Tuesday morning. This will be the first generation of women with fewer rights than their mother, she added. The longtime abortion rights leader was joined that morning by dozens of other concerned, angry, and even astonished lawmakers who read the news overnight that a draft opinion in a Mississippi abortion law case written by Supreme Court Justice Sam Alito had been leaked to the news website Politico. It's the kind of thing that rarely happens, and it was a bombshell. In that draft, which has since been authenticated by the court, Alito wrote that the court's 1973 Roe v. Wade decision, the landmark decision that guarantees a woman's right to abortion, would be overturned. Another important decision that confirmed and modified Roe, the 1992 Planned Parenthood v. Casey decision, would also be thrown out. Roe was egregiously wrong from the start, he wrote. The Constitution makes no reference to abortion. No such right is implicitly protected by any constitutional provision. Any such right, he added, must be deeply rooted in this nation's history and tradition. Chief Justice John Roberts called the leak a singular and egregious breach of trust, and he was quick to note that the draft is a draft and not a final decision. But that draft appears to have won the support of 5 of the 9 justices. 3 of those justices were nominated by former President Donald Trump, and all 3 indicated in their confirmation hearings that they considered Roe v. Wade precedent. Some Democratic lawmakers say they've been lied to. Even 2 Republican senators, Lisa Murkowski and Susan Collins, expressed surprise. Murkowski told reporters her confidence in the court has been rocked. The Senate Majority Leader Chuck Schumer has vowed a fight, promising a vote on a bill that would provide abortion rights protection via federal law. But with a filibuster in place, it's hard to see how a vote like that could make any difference. And even without the filibuster, it's not certain the Democrats could get the 50 votes needed for Senate passage. And as dramatic as the impact of that decision might be for women's health and reproductive rights, there's even more potentially at stake. Speaking to reporters inside the Roosevelt Room of the White House yesterday, President Biden said the overturning of Roe v. Wade could unravel a range of privacy rights. What about the right to marry someone of a different race or a different gender? What about access to emergency contraception? There are so many other things that are also not specifically mentioned in the Constitution and not deeply rooted in our history and tradition. So what happens next? Well, in 25 states like Maryland, existing laws allow abortion either in the for the first 2 trimesters or up to viability. But 13 states, mostly in the South and Midwest, have prepared for a possible overturn of Roe by enacting so-called trigger laws, which would effectively ban nearly all abortions almost immediately after a decision from the Supreme Court to overturn Roe v. Wade comes down. Now, in those states and about 10 others also with existing restrictions, many women may lack the resources to travel to states where abortion would remain legal and would therefore be required to either carry an unwanted pregnancy to term or seek a risky and unlawful abortion closer to home. And the CDC says in 1972, and that was 50 years ago, but 1972, the year right before the Roe decision, 130,000 women obtained illegal abortions or self-induced procedures. 39 of them died and thousands were hospitalized. Well, in order to find the very best people to analyze the issues and answer your questions, we had to look no farther than our own Francis King Carey School of Law. Our guests today are Professor Leslie Meltzer Henry, Professor Mark Graber, who is also the Regents Professor for the University System of Maryland. And we hope, and I see he's not here yet, he's having some trouble connecting, but we're going to work on that. We hope we're going to get Professor Robert Percival, who's also the Robert F. Stanton Professor of Law. Now, I have to tell you, this program is being recorded and will be posted on our website. Later in the program, you'll have a chance to ask your questions. Please write them in the chat area. When the time comes, we'll call on you by name and I'll open your mic for you. So all you have to do is speak up. Now, please welcome our host, UMV President, Dr. Bruce Jarrell.
Thank you, Alex, and it's a great pleasure to be here. And I thank all of you in the audience for attending this. As Alex said, it's really important that you get your questions to him early because I'm sure there will be a lot, and we certainly want you to interact with our experts. It is my pleasure to be here with 3 law school faculty members. One of the joys of my job has been to learn about other schools. As many of you know, I spent several decades in the School of Medicine, and yet my interaction has been to learn about the other schools. And I don't mind telling the audience just how impressed I am with our School of Law and its expertise. I'm also impressed with how little I knew about the law. And whenever I read about the law, I have to have my dictionary open to look up these terms. But in any event, it is great to have such a well-known school of law and experts here. And I want to welcome Professor Graber, Professor Henry, and I see Professor Percival about to appear there. So,
He's about to appear. He just has to turn his camera on.
oh, he has to
So,
turn his
Mr. Percival,
camera
please turn
on.
your camera on. Yeah.
So let me begin with Professor Graber as my first question. Should we assume that this draft opinion, more or less, is what the court is going to finally end up with, or should we withhold all of our judgment? It's really tentative. So how sort of fixed is this opinion as you read it? Come off mute, Mark.
Okay, sorry. The details are not fixed, but there's very good reason to believe, even before this draft was released, there are 5 votes to overrule Roe. That's what it looked like at oral argument, and the justices refused to stay a Texas law which essentially banned abortion after about 6 weeks. That law was flagrantly unconstitutional. If there was a vote that said we should merely modify Roe, that vote should have been to throw out the Texas law. That didn't happen. So we can presume there'll be editorial changes, as there always are. But this looks to be what the vote is.
Professor Henry or Professor Percival, do you want to add anything to that?
Yeah, I can say that the court actually had an emergency motion to allow the U.S. government to contest the Texas law. And the court actually sent it back to the lower courts and said, we expect an expeditious response. And instead, the Fifth Circuit referred it to the Texas Supreme Court to delay and delay. And the Supreme Court did nothing about that. So I told my constitutional law class, that has to indicate to me that the court's already voted to overturn Roe v. Wade, and that's the reason that they're tolerating this intransigence from the lower federal courts on the emergency motion.
Professor Henry, anything to add?
I would just add, drafts are often amended in consultation with other justices at this point in the process. And it's possible that in cases, I don't think this is one of them, justices might change their votes after the draft. This case, I entirely agree with my colleagues, is largely going to come out in terms of outcome as it appears in the draft. I actually think the interesting question is whether it will be a 6-3 or a 5-4 decision. We don't entirely know yet whether Chief Justice Roberts plans to join that majority opinion. And so I think that will be what we learn when the final opinion comes out, but not the outcome.
So sort of a related question then. So we're all seeing the steps of the Supreme Court with protesters and now barriers. Does the Supreme Court respond to any of those kinds of activities like our senators and legislators may do so, or are they really refractory to that kind of activity? Professor Percival?
They're not supposed to, but they, the old saying is the Supreme Court follows the election returns. And it's possible that one reason that it was leaked, and it's completely unknown as to who leaked it, was to either solidify the conservative votes because they would get so much grief in the future if they changed their votes, or to produce such an enormous public reaction that the court would back down. Normally, the court does not back down at all. So I don't think those protests will have an effect. Now, it is also true that while changes can be made at any time until the opinion's released, the Wall Street Journal was so ghoulish to say, please issue this opinion right away because one of the justices in the majority might die, in which case their vote isn't counted. They actually said maybe some fanatical abortion group will try to bump off one of the justices. It was, really shocking that anyone would say that. But that's about the only thing that I think that could actually change the outcome in this case. If suddenly one of the justices died, it happened when Scalia died just before the court was about to issue a decision reversing a longtime labor law doctrine. And it took the court 2 more years when it got a new member before it could reverse that doctrine.
Could I add one thing? It's interesting, and Professor Percival raises a good point about whether the court follows what happens in our national elections. This is a very bizarre time in which we are essentially under what I would call minority rule. So when Roe v. Wade was decided in 1973, it was decided as a 7-2 opinion, with 5 Republican appointees joining 2 justices who had been nominated by Democratic presidents. This decision, if it's a 5-4 decision in which all the justices voting to overturn Roe are Republican appointees, Justices Alito, Thomas, Gorsuch, Kavanaugh, and Barrett, that would be remarkable. Of course, if John Roberts joins the majority and it becomes a 6-3 decision, 5 of those 6 justices will have been appointed by presidents who didn't win the popular vote when they were elected and inaugurated. So it is a really interesting time to think about the effect of elections and their intersection with the Supreme Court.
Anything to add there?
Well, just briefly, I don't think any judge is surprised there are protests outside the court as a result of an abortion decision. If they are, they need to be removed for senility. And the question is, who do they listen to? The big pro-choice group on the right side of the court or the big pro-life group on the left side of the court? So this is not one of those where politics now will influence. Politics, as Professor Henry has pointed out, has influenced, but that politics has already taken place.
Gotcha. Let me go to another question before we get to the Roe versus Wade question. So this was leaked, and the document, as you go through it, appears to be a pretty complete document to me, what was leaked. I know, Professor Percival, you clerked for a Supreme Court justice. Could you tell us a little bit about the safeguards within the chambers and maybe some speculation on what's going on here?
Well, this is really totally unprecedented to have an actual first draft of a majority opinion leaked in full prior to the decision being released. The usual safeguards are that all the clerks know from day one that everything is totally confidential and they're not allowed to see anything about the decision. The main preventative measure to prevent leaks at the time I clerked, which was 40 some years ago, was to tell the clerks you can't take your work home with you so that no one can rummage through your briefcase and find out anything about what the court's about to do. Now, it was very interesting, though, the term I clerked, Bob Woodward and Scott Armstrong came out with this book, The Brethren, which was a comprehensive account based on interviews with former law clerks about how the court decided Roe v. Wade and other major cases. It was a total earthquake within the court at the time. Chief Justice Berger was enraged. It came out later that Justice Blackmun had actually told his former clerks it was okay to talk to the authors because they were talking about cases that had been decided long ago. But, and the court said, the Chief Justice said, this is going to really damage the court. I don't think it really did in the long term, because when I subsequently went through Blackmun's papers, virtually everything in the book of significance was totally accurate with respect to the court's internal deliberations. And of course, when Justice Marshall's papers became available quite quickly after his death, they also said this would do long-term damage to the court. I don't think it really did.
About other comments, Professor Henry or Graber? We can't hear you, Leslie. You're muted.
Sorry about that. It's interesting to note, if you go back to 1973, and in the hours before the Supreme Court announced the decision in Roe v. Wade, Time magazine actually published the outcome of the case because one of the clerks, Larry Hammond, had leaked it to an old roommate who happened to work at Time magazine. And there was a delay in the court announcing the opinion by a few hours. And it just so happened then that the Time magazine issue was published and came out before the court announced the opinion. And so there's been something like that, but nothing quite like this, with the exceptions that Professor Graber and Percival note.
And just to note on exceptions, in fact, in the 19th century, particularly before about 1880, most judges were closely associated with political parties and political figures. They corresponded regularly with political figures and the lawyers who argued cases. So Dred Scott, probably the most famous opinion, was leaked to President Buchanan when he was asked to influence the judges. Another very famous case called the Prize cases deal with Lincoln's blockade. You see the judges writing the lawyers saying, I'm voting for you. You need to make this argument. So this is a return to the 19th century world of polarized politics and judges intimately involved with those politics.
Great. Well, it's an exciting time, I tell you that. So let's get into the actual overturning of Roe versus Wade. Professor Henry, you're an expert in this area. What do you see happening nationally occurring with this change in position?
That's a great question. I think there will be a few immediate results and then some that will likely come down the path in the weeks and months afterwards. I think immediately, if the court overrules Roe and Casey, we will see at least 26 states that have signaled they will further restrict or ban abortion. We'll see them do that. For the roughly 40 million people that it's estimated live in those states who could become pregnant and are of reproductive age, they will face potential unwanted pregnancies in states that are hostile to abortion rights. And so for those individuals, there will be an immediate decrease in their access to what many people would consider essential components of healthcare. Despite major advances in birth control, nearly half of the people who have unintended pregnancies were actually attempting to prevent those pregnancies. And so for those people not to be able to access legal abortion is a really critical thing to think about, I think, is both a public health issue and is a personal individual rights issue. Without a federally protected legal right to abortion, states can determine the extent to which they'll allow abortion. And so people who are in states that are hostile to abortion are likely going to have three options. They can carry a pregnancy to term against their will, which we know correlates with greater health risks to the fetus, like preterm birth and low birth weight and impaired child development. They can seek an abortion in a state where it is legal, but that option is likely to be foreclosed for the vast majority of people carrying unintended pregnancies, many of whom are disproportionately young or impoverished or live in areas where there aren't likely to be ways or means to access abortion. And then finally, of course, there's the possibility that was mentioned at the top of the show, which is they could seek an illegal or underground abortion with all of the health risks that come with that. So I think this is a tragic time, both for individual rights, but also more broadly for public health.
You used the word foreclosed, and I've heard another way to foreclose it, and that is that making it illegal for someone in another state to perform an abortion of a Missouri citizen, for example, or that kind of thing. Could that really happen?
So that's an interesting question. And there have been a few individuals who are on the anti-abortion side of the debate who have advocated that states try to restrict travel between states for abortion, which would not be permissible if a state made that decision because it would contravene the federal right to travel interstate. But what now states are considering, I hear, is doing something like Texas did, which is getting out of the business altogether of saying you can't come to our state, or we'll prosecute you if you're a member of our state and go to another state for an abortion. We're not going to do that. Instead, we're going to allow citizens of our state to sue you civilly for that, which would be different and makes the state somewhat immune from those kinds of lawsuits.
Professor Percival or Graber, anything to add on that?
Well, I actually use this as a exam question in my con law exam because after the oral argument in this case, the Food and Drug Administration in December changed its guidance in order to make abortion pills more readily available, that you could get them from certified pharmacies instead of having to go to a doctor's office. I suspect there'll be more efforts to make abortion pills more widely available. And then the states may start trying to combat that by enacting their own laws prohibiting the use of abortion pills. And does that mean they're going to be searching postal shipments that are governed by the U.S. Postal Service in the hands of the federal government? It's going to be give rise to lots of conflict between the state and federal government. The federal government and the Food and Drug Administration certainly have the power to preempt local regulations if they're premised on a notion that abortion pills are unsafe because the FDA has deemed them safe. But if that's just based on moral grounds, it's a closer legal question. So I think you're going to have endless battles involving federalism between states and the federal government as the Biden administration tries to do what it can to make abortions more readily available to those who need them.
Professor Graber, and also what's going to happen in Maryland?
What's going to happen in Maryland is right now easy. Maryland is abortion is legal in Maryland. Indeed, it's a constitutional right. And in fact, Maryland will announce, by the way, if you can get here, we'll do your abortion. There's a fight between the Maryland legislature and the governor over additional money to train more people to do abortion. But I like to say when I teach, what's really crucial is where the battlefield is. There'll always be battles over abortion. But if you're in a state where the battle is over, how much money are we giving to train additional providers? You're in a fairly pro-choice state. What is going to happen, as people have alluded to, is the issue is shifting to the national government. In particular, the commerce power of the national government. Article 1, Section 8 gives the federal government the power to regulate interstate commerce. Abortion pills travel in interstate commerce. You order them in one state, they are shipped. Does this mean a federal law saying you can't regulate abortion pills, this is a national regulation, trumps a state law? Abortion is a good or services. People charge. Can the federal government say there is an interstate market in abortion? One, we're going to shut down that market, just like we tried to shut down the market in marijuana. Two, we're going to encourage that market. You can't shut it down. That's where the battle is now going to be taking place.
Well, Leslie, you look like you were going to say something.
Yeah, I just wanted to clarify one bit of this. So under Maryland law was very progressive in the early 90s. And in 1992, those of you who are living in Maryland at the time will remember that there was a ballot 6, and it resulted in this progressive, as compared to other states in the country right now, Maryland law that said the state can't intervene in a woman's decision to have an abortion before the fetus is viable or at any other time in the woman's pregnancy if an abortion is deemed necessary to save her life or her health, or if the fetus is affected with a genetic defect or serious deformity or abnormality. And I use the word woman and fetus in the way that the the law is written. And so that's been on the books for a long time. And it's been, I would say, in some ways strengthened in recent years. This past July, House Bill 937, the Abortion Care Access Act, took effect in Maryland and actually expanded the number of healthcare professionals who can provide abortion services in the state. So it's no longer just physicians who can provide it. It's also nurse midwives and physician assistants who are trained in providing abortion care. And as Professor Graber alluded to, the bill also established the abortion care clinical training program, which directs the state to spend at least $3.5 million a year to develop training programs to increase the number of people who are trained to provide abortions. And at least the legislative history of that suggests that part of the aim was to try to diversify racially and ethnically the people who are providing abortion care. And I think that is really important to note. There is, as he noted, this issue of a constitutional amendment that's come, before the House in Maryland, but the Senate has sort of refused to go further on it today.
Alex, we must.
There is. Yep.
Go ahead, Leslie, finish.
I was just going to say, I think for Marylanders, this means that we're in a very different place than a lot of people, most people in the country.
Gotcha. Alex, we must have questions at this point.
I was going to say, I hope you're ready to take questions. We have a lot of them on different parts of this, so I'm going to try to break them down. I'm going to start with Bruce Kruger, who has a question about the politics of this, because this is now becoming a political issue, even more than before. Bruce, go ahead.
Okay, am I?
You're on. Yeah, absolutely.
Okay.
Go ahead.
Okay, great. Well, I noticed that Justice Alito suggested in this leaked.
Bruce, we can't hear you very well. I'm going to interrupt you to ask you to start again because you came out strong and then your volume went away.
How about now?
Yeah, speak up a little bit. We should be okay.
Okay, I'll have to shout, I guess. Okay, so Alito, as I recall, suggested that overturning Roe would return policies to the states, to leave the states to decide for themselves. But the Republicans now in Congress, some of them at least, are arguing that Congress should pass a universal bill that would ban abortion nationwide. So I'm just wondering how the conservatives would support. Are they going to go for a states' rights position and maybe would not accept that? Or are they going to say, well, okay, if Congress says no abortions anywhere in the United States, that's okay with us?
Who would like to address that one?
Well, it certainly is the dream of the pro-life movement to ban abortions nationwide, and the dream of the pro-choice movement to have Roe v. Wade in place, which effectively bans prohibitions nationwide. I'm sure they're going to be great political battles, but Congress currently is in gridlock because of the filibuster rules in the Senate. So I doubt if you're going to see any immediate legislation. There's lots of speculation as to whether this is going to mobilize additional voters to come out for the midterms. It remains to be seen if that will happen and whether maybe that was a motive of one side or the other to leak this draft opinion before it's actually released by the court. But I think it will have a big political impact. It's just hard to say how big will that be and who will benefit most.
This isn't an issue like elementary school curriculum where you could really say, I hope in my state they read the books I think, but if they read different books in Georgia and Idaho and California, that's Idaho and California. It's an issue more like slavery, where you either are for it or you are against it. You don't think it's a particular good idea that either half the states allow the killing of unborn babies or half the states deny women fundamental rights. You think all the states should do so. So inevitably, once it's returned to the states, there are going to be battles in a different national institution. by everyone who wants a national rule. We all agree on that. We simply disagree on the national rule.
Bruce, you're muted. I'm going to unmute you. Go ahead. Go ahead.
That's why I love interacting with the law school. I learned so much. Alex.
I'm going to bring in Joshua Hitch, who wants to talk about, how we got here, why we got here. Joshua, go ahead and ask your question.
Good morning, everyone. The question I have is that in reading about this, I've read that there are talks to codify Roe versus Wade. And my question to that is, what is a codified law and how is it different from the precedent of a previous court ruling? And if codifying Roe v. Wade would have protected it, why was there no attempt in the last 50 years when maybe there was a more democratic Senate or a bigger, push to protect it, if that would protect it?
Well, there have been bills introduced to that effect. They didn't get enacted in part because some said they weren't necessary because we had Roe v. Wade. And you may recall that when these very conservative Trump justices were nominated, often it was argued, oh, the left is just trying to scare people by saying they're going to overturn Roe v. Wade. Now that Roe v. Wade has been overturned, or will be as soon as this decision is issued, there probably will be more impetus for such legislation. But again, given gridlock in Congress, who knows what will happen?
Anything to add, Professor Graver or Henry?
I think the only thing to add is to maybe get at the difference between a Supreme Court decision and a codified law, which goes back to thinking through the separation of powers that are really at the heart of American government. And so, although it may feel like the Supreme Court is making policy if it overturns Roe v. Wade and Casey, that's not its job. The job of the U.S. Congress is to pass laws, and the job of the judiciary, of course, is to review claims that those are unconstitutional or otherwise contravene the law. So this is a moment in, I think, American democracy where there's been a lot of bleeding of those otherwise strong boundaries between the various parts of our government.
And that was discussed in the written decision that was printed about, it read more like legislature, the Roe v. Wade original decision.
Well, that's long been a criticism of Justice Blackmun's opinion in Roe v. Wade. He went farther than simply overturning the Texas law at issue there and actually created the trimester system, which many people thought was not necessary to deciding that case, and looked more like legislation than a judicial opinion.
That's how we got Casey, right?
Yeah, well,
Mark?
to chip in, actually to have a little bit of a disagreement, which is always good. I'm inclined to think the quote, the Congress does policy, the court does constitution, doesn't describe historically what's going on. An amazing amount of constitution gets done in Congress, an amazing amount of policy gets done in courts. What the shift is, until about 1980 and really 2000, the parties were internally divided on abortion. Ted Kennedy begins his career, Mr. Liberal, pro-life, and votes pro-life early. So it's very hard to get legislation when your parties are divided. And most parties said, this is a hot potato, we'll kick it to the courts. People were actually very grateful the courts took it. It's only around 2000 where we start to get a Democratic Party that is clearly the home if you are pro-choice, a Republican Party that's clearly the home if you're pro-life. And we've had lots of divided government since. So it turns out politics is right now too closely divided. What we're seeing in some sense is a loss of a center on abortion that might be able to pass legislation.
Okay, Alex, let's go to the next question.
I'm getting a tidal wave of questions
Wonderful,
all around
yes.
the same topic, though, is sort of all the other things that people worry about could be eroded. Some of those other, not strictly enumerated, rights, whether it's to, emergency contraception or marriage rights. I'm going to bring in Lori Powell, who's one of those. Lori, go ahead and ask your question. Lori, I've unmuted you. Go ahead and ask your question. Well, I guess I mentioned the gist of it. There are people who are worried about different aspects of this in our audience. Some are worried about, LGBTQ rights. They're worried about, same-sex marriage rights. They're worried about contraception. What do they have? Is it a reasonable fear? Do they have something to worry about?
Yes.
I think, yeah.
Bob.
Okay, I think the best indication of that is the very fact that Alito's draft opinion goes out of its way to say, no, this doesn't apply to these other areas, even as it is rejecting the doctrinal foundation of privacy rights, guaranteeing rights to same-sex marriage and contraceptive privacy and the like. He's trying to foreclose more political blowback by that. But I think that if the opinion comes down in the current form, it certainly is going to be a roadmap for attacking those rights in the future.
Professor Henry?
I think there's two ways to look at this. The first is to say, well, what's next on the court's to-do list, right? This looks like an exercise of raw judicial power, and maybe that sounds cynical to some, maybe that sounds realistic to others. But if you take that perspective, and look at the fact that the court was willing in this case, or appears willing in this case, to overrule a super precedent, right? A case that's been upheld multiple times by different federal courts. If they're willing to invalidate Roe and Casey, then the case is upholding a right to same-sex intimacy and same-sex marriage might be next on the chopping block. I think that's one way to look at it. And as Professor Percival said, that is signaled pretty clearly in Justice Alito's opinion. The other way to look at it is more optimistically. The holdings in the same-sex intimacy case, Lawrence versus Texas, and the same-sex marriage case, Obergefell versus Hodges, are arguably grounded not just in due process, but also in equal protection to some degree. And so those cases might be more insulated from being well, at least from what some people see as the naked power grab by the Supreme Court in this case.
Professor Graber?
I think we need to begin by recognizing that pretty much all contemporary rights are unenumerated. There is no provision in the Constitution that says there's a right to private gun holding. Bear arms is a military phrase used by the framers as a military phrase. Conservatives have found a right to private arms control. It's an unenumerated right, and the good news, if you're a conservative, it's in no danger after Roe is overruled. The framers of the 14th Amendment adopted race-conscious programs. There is no right enumerated that says equal protection means affirmative action is wrong. It's a decision about what equality means, and you and I can disagree. So what is going on is an attack on a particular notion of unenumerated rights stemming from privacy, that there are certain decisions that historically were foreclosed because they violated certain religious creeds, but people came to understand in a modern society, people ought to be allowed to make about sexuality and families. Those are going to be under siege. And the fact that you and I, as good progressives, can find lots of constitutional hooks isn't going to help very much with Samuel Alito.
Okay, Alex.
All right, this is not exactly a legal question, although a follow-up did come from one of your colleagues, so I'm gonna put it in here. It has to do with maternal mortality, obstetric health. I'm going to bring in Marcella Leith. Marcella, go ahead and ask your question.
Hi, Alex. Thank you. One of the things that was brought up earlier is Maryland's most recent change to legislation allowing for other healthcare providers, nurse practitioners, and nurse midwives to perform abortions. And additionally, I've heard in all these conversations that there's a potential that an entire generation of medical providers will not actually learn how to perform safe abortions should Roe versus Wade be overturned. My question, I guess, within that context is how, or if any of you could speak to the effect of overturning Roe versus Wade on obstetric or maternal mortality. You know, the US already has a very high maternal mortality rate with over 700 women dying each year as a result of pregnancy or delivery complications, which is huge compared to other high-income countries and countries in the global north. So I'm just wondering if you could speak to that, or if any of you could speak to that.
You're muted, Professor Henry.
Thank you. I think what you articulate, Marcella, is exactly the public health set of concerns that I have. And we know from the time of Justice Blackmun's opinion, he says this in Roe v. Wade, to the present, early term abortions are safer than childbirth. The health risks associated with childbirth are 14 times greater, the National Academies of Medicine and Sciences recently found, than the risks associated with a pre-viability abortion. And of course, in some states, like Mississippi, carrying a pregnancy to term, it leads to an even higher risk of fetal and maternal mortality. And that's particularly so among people of color. So there is, I think, real reason to be concerned about the lack of access to abortion care in some states and the possibility that for a whole variety of reasons, individuals might be compelled to carry pregnancies to term or seek later term abortions because by the time they're able to get to a neighboring state, they're further along in their pregnancies.
Any other comments to that issue?
All right.
Yours for Leslie?
Well, you know, this, of course, is not a one-sided issue. It's a country that's divided, and or there are a lot of people, and there's some people in our audience who are concerned about, you know, the rights of the unborn. I'm going to bring in Aaron Dada to ask that question. Aaron, go ahead.
Yes, I was sort of interested in the history of why this question seems to be about women's rights as opposed to not only the rights of the unborn life, but also of the father. Why is there no discussion around how this decision would impact their ability to be involved with the decision-making process?
I'm happy to take that, but Bob, it looks like you might want to say something first.
Go ahead, that's okay.
I do want to say something first about the piece involving the other party, right, to this, the person who impregnated the one who is pregnant. The Supreme Court has generally found that that person does not even warrant notice in this case. And I want to just bring that up because Justice Alito was a judge on the Third Circuit Court of Appeals when Planned Parenthood versus Casey was decided in the lower court before it came to the Supreme Court. And that case involved a provision that said that husbands should be notified by their wives if their wives want to seek an abortion. And the case ultimately, of course, you know, went to the Supreme Court in Casey versus Planned Parenthood, or Planned Parenthood versus Casey. And the court struck down that Pennsylvania provision that said that husbands don't deserve or shouldn't be illegally entitled, at least, to notification by their wives. And the concern was that it might actually create situations of intimate partner violence for the pregnant person. Of course, there's assumptions in there, right? That the husband is the, as you say, father of the fetus. But the court really pushed back against that. Justice Alito, though, in the lower court, said that that kind of notice was acceptable. And he was the outlier. So I think it's important to note that because he's now actually authoring this majority opinion. The question about personhood is one that the Supreme Court decided not to take up in Roe v. Wade. Justice Blackmun said that that question of when life begins is one that should be left to philosophers and theologians. And so at least as a legal matter, that's why it's not been part of the court's jurisprudence.
And I just want to add, I'm the father of 2 adopted children from Chile and Paraguay. And I just wanted to say how out of line this decision will be with the rest of the world. They are very heavily Catholic countries, and it's possible that if abortion had not been illegal, that neither of my son or daughter would have been born there. But now the Supreme Court of Colombia has declared a right to abortion services. Chile, for the very first time, has legalized abortion. Countries all over the world are moving in that direction, and our Supreme Court is going dramatically in the other direction.
It's interesting if you look at the history of abortion. It's never been about the unborn. We know, contrary to the Alito opinion, a lot of historians of the time period, I'm not an historian of the time period, but historians of the time period have chipped in, and they've said, in fact, no, they can't find prosecutions for abortion before validity. And these are people who have gone to the early court records and gone one by one, looked at all of them. In the mid-19th century, there is a doctor's crusade to professionalize medicine. Part of it is to take abortion out of the hands of non-doctors, and part of this resulted in a lot of bans on abortion unless your doctor thought it was necessary. Turned out this resulted in a public health crisis. So if you look at the first movements for liberalizing abortion, it's public health specialists who are in fact noting, as Professor Henry has pointed out, that at some point illegal abortion was the second most biggest illegal activity in the country next to gambling. And that was the third leading cause of death among a certain population. Then in the 1960s and 1970s, as we developed a different conception of women, abortion became a woman's right because, in fact, if you cannot control your fertility, you cannot be an equal in the public world. So that's the history.
Can I add one thing to that? And here I'll just slightly disagree with Professor Graber, which is to say, if you look at the linguistic changes that are happening across these Supreme Court opinions from Roe v. Wade to the present, it's really important, I think, to focus on when the court is using the word fetus versus baby, when it's using the word pregnant person versus mother, when it's using the term healthcare provider versus abortionist. With Roe, you start with the more medical, scientific terms. By the time we get past Casey to a case called Gonzalez versus Carhart, in which the court upholds the federal Partial Birth Abortion Ban Act, the court is using the language abortionist, baby, mother. And the pregnant person, in fact, is not even articulated in that case. They aren't even part of the picture until more than a dozen pages into the opinion. So I think there is a really significant shift in Justice Alito's opinion in this case, if it turns out to be the law, is much more in keeping with the Gonzalez case. He uses the word abortionist, he uses the word baby, he uses the word mother.
I take that as a friendly amendment, not as a disagreement.
It is. It absolutely is.
Alex?
All right. Another area that has drawn the ire of a lot of people in our audience is the question of, what's going on internally with the court. We went through a period where, you had a justice who couldn't get a confirmation hearing, and then you got a bunch of fast hearings. And so let me bring in Kendra Petrick to talk about this. Kendra, go ahead with your question.
Thank you. Good afternoon, everyone. So I wanted to know, there's been a lot of talk about the candidates during their confirmation hearings being less than forthright about their position on Roe v. Wade. is there any penalty for that? Are they sworn in? Do they have they sworn to be honest in their opinions, or did they choose their words carefully enough not to draw any ire in that regard?
Great question.
Well, they're under oath at their confirmation hearing, so theoretically they could be charged with perjury if it could be proven that they intentionally lied. Given that Alito's draft opinion says that Roe v. Wade was egregiously wrong from the start, it's rather hard to believe that any justice joining that truly hadn't thought about Roe v. Wade at the time of their confirmation hearings. And I think it's the case that none of them would have been confirmed if they had been frank in saying their objective was to overturn Roe v. Wade. Now, of course, the president who appointed the three most recent justices, President Trump, said, I'm appointing them because I want Roe v. Wade overturned. And that's exactly what the court is delivering now. So it can't but help to make this make the court appear totally politicized. And this is so different from when I clerked way back when on the court, where you didn't have these sharp ideological divisions. The justice who I eventually clerked for, Roe v. Wade was decided 6 years before I clerked for him. Justice White was one of the two dissenters, and he charged that this was an exercise in raw judicial power. But one of the things he also said in discussions with his law clerks was that he wasn't into creating and recognizing a whole lot of new constitutional rights. And in part, he said, because when you recognize them, you can't go back. The court should not be in the business of repealing constitutional rights. And this would be a breathtaking exercise of the court repealing one of the most significant constitutional rights that's been recognized and reaffirmed for nearly 50 years, which is why I think this is so significant, both in making the court appear more politicized, which it is, and in fundamentally maybe putting us in the direction of what other rights is the court going to strike down.
It's a more politicized time. You get more politicized courts. I'm not, as people have gathered, a great believer that the court is above it all, has ever been above it all, though there are disturbing things. I've publicly declared that two of the justices in the majority are perjurers, and not simply perjurers for not disclosing their opinion about Roe. And it's rather interesting. Nobody has said I'm wrong. Nobody has said a suit for libel. That it may be a court can be politicized, but perhaps a number of the justices have gone too far. And even in the Alito opinion, you don't have to use the word abortionist. You don't have to call approximately half the country idiots and cretins for believing differently than you do. And the same is true on the pro-choice side. You might actually acknowledge that people disagree, but we're not in that environment. And this is what produces an opinion like Alito's opinion and a leak like the leak.
Alex, we got time for one last question, and I know you've got 100 of them.
I've got 100 of them, but I will say that there were also questions about whether the court is really functional. You know, we've talked about court packing, which is not new. I know Roosevelt tried to do it, but people are really frustrated. Let me bring in Isabel May with maybe our final question here. Isabel, go ahead.
Thanks, Alex. Thanks, everybody. Good afternoon. Thanks for taking the time to educate us on this issue. So I'm wondering, and this comes from not having grown up in this country and learned about the Supreme Court structure and the judicial structure of this country in my graduate studies in my fields. But so I'm used to different legal systems. So I'm really wondering, I would love to hear your thoughts on, do you feel that the structure of the Supreme Court as originally envisioned has run its course? Are there some alternative ideas that legal scholars have been discussing to avoid a situation where a court with lifetime appointments, right, the packing issue, for judges leaning a certain way can enact laws that go against what most Americans believe in. I think the recent number I've read, 70% of Americans believe that Roe should not be overturned. I'd love to hear your thoughts.
Well, President Biden appointed a commission of legal scholars on a bipartisan basis to look at Supreme Court reform. One thing they looked at was adding additional members of the court, which can be done by simple legislation because the Constitution doesn't specify the number of justices. They also looked at having term limits, and there seemed to be a lot more support for term limits than expanding the size of the court. I think the fear is that if the Democrats did that, then once the Republicans get in power, they would expand it even more, and that would have endless consequences down the road. So it's certainly being looked at because there's so much frustration. This court is so out of touch with the American public right now.
Professor Henry?
I think that's exactly right. Right now, we have a Supreme Court that is largely out of touch with the American people who, for decades now, have voted close to 70% in favor of upholding Roe v. Wade. So it's a Supreme Court of minority rule, I think it's fair to say, at the moment.
Professor Graber, you get the last word.
Okay, well, first, I think American institutions as designed collapsed in the second year of Congress in 1791. So our government simply doesn't function the way the framers thought, and it hasn't functioned the way the framers thought for over 200 years. I think in the long run, the real lesson is if you're pro-choice, vote, go out, win elections, do what you have to do to win election. It's a court that is not dysfunctional if you are conservative. It's a court that's following an agenda of a particular programmatic party, which I don't happen to like. But the solution in the long run is not to evade politics, but to become more active in politics, because if our politics changes, the court will change.
Well, we're out of time. That has been breathtaking, I have to say. So for the audience, thank you for your questions and your participation. Also for the audience, you can see why I love interacting with our law school. Where could you get discourse like this anywhere else? So I want to thank Professor Graber, Professor Henry, and Professor Percival. This has been a wonderful session. We may have to visit this one again, I suspect. So thank you very much, and thank you all for participating. Until the next session. Thank you.